The Honourable Leanne Dalzell.
Chairman, I'd like to follow on from that excellent contribution from my colleague Chris Farfoy, where he basically ended with reference to the Legal Assistance Sustainability Amendment Bill name, because of course the word sustainability has been removed, and I too agree with him that sustainability should have been removed from the bill and probably shouldn't have been in there in the first place, although it was there for a particular reason, and that was it was a cue for explaining what the government was actually trying to do, which was to cut the cost of legal aid. But of course, when one cuts costs in one area, there is something else that always happens somewhere else. And isn't it unusual that, normally speaking, in a regulatory impact statement, you can't find where that blowout's going to occur, because they only look at the short-term impact, and they look at the impact on the particular budget, and they're not looking in the long term. But actually, in this regulatory impact statement, they've done an excellent job, and I want to congratulate those that put it together, unfortunately without the benefit of wide public input, because of time pressures and the budget-sensitive nature of the issues under consideration. So, and we were told that the Select Committee process would, of course, substitute for the public input, which I actually don't think that we do justice to the need for public input on matters so important as this, by saying that the Select Committee process will do, because you can put in a written submission, then turn up and have your time in front of the committee for 5-10 minutes, as an individual. And I think that that's a bit of a problem. But I'm going to quote from an individual's submission, because I want people to know that this isn't about what lawyers think or about what people that work within the system necessarily think. It's the very direct and real impact that makes this bill not sustainable, and that's why the word is appropriately withdrawn. But let me just read out the number of risks that were made. One, a change of purchase approach is required, but is likely to be resisted by some parts of the legal profession. Well, that's happened. There are people who've pulled out of legal aid all around the country. In fact, we heard evidence from one person who'd actually left her firm and set up her own practice so that she could continue to offer the degree of legal aid work to her client base, which were largely migrants. This was down in Christchurch, refugees and migrants. And I say, good on her. She was extraordinary. Reductions in the price paid to lawyers could create gaps in provision, particularly in the family and civil jurisdictions. Well, that's exactly what's happened, particularly in smaller centres. The introduction of income and asset thresholds for the criminal means test will be in tension with Section 24F of the New Zealand Bill of Rights Act, and that was something raised by this individual submission that I'm going to refer to. It could also delay some court cases if judges defer proceedings because of inadequate representation. Restrictions to eligibility will disadvantage people on low incomes who have few options to find legal services elsewhere. Generally, this includes young Māori men in the criminal jurisdiction and women and children in the family jurisdiction. And I went through the list of the sequence of events that actually discriminates, not deliberately, but in fact it discriminates against Māori, and that's why we have a higher proportion of Māori in our prisons. Starts right from when they get stopped in the street all the way through the process, much more likely to end up in jail for longer. But the final one, which was the interesting one because it's raised in another submission that I want to refer to, and that was withdrawing legal aid for low-income groups is likely to lead to additional costs elsewhere in the justice system. In particular, it may increase the number of self-represented litigants, with flow-on costs due to delays, additional assistance required from court staff and the judiciary, and higher numbers of appeals of decisions. So this refers me to Anita Cochrane from Auckland, who's made this submission, saying that she believes it to be a travesty and makes a mockery of the New Zealand Bill of Rights Act. And I congratulate her for being so forthright in her presentation to us. What she was saying was that 24F makes it absolutely clear that People, Mr
The
Chairman,
Honourable Len Dalzell.
Mr Chairman, shall have the right to receive legal assistance without cost if the interests of justice so require and the person does not have sufficient means to provide for that assistance. She talks about not having the right to get a fair hearing if you can't afford to pay for a lawyer. And I think that that is a statement that is well made. But what she went on to do was to speak of her own experience, and she didn't talk about the particular matter that took her to court, but it was a case that took her 1 year, 5 court attendances, 4 of which were all remanded by the prosecution for some reason. For example, the documents weren't there, they lost some evidence, there was another important case going on, and it was only the 5th attendance and the 5th attempt by the prosecution to remand the case yet again that I demanded that the case go to court or they withdraw their charges. Each time she had to pay her lawyer $2,000 to appear, and she was making the point that she earned $51,000 a year, owns a car worth $2,000, couldn't afford to own her own house, but had no capital or other assets. The opposition, meaning the prosecution, then tried to bully me into pleading guilty. I had to weigh up the cost of trying to find more money, as I had paid out so much and still had not seen a judge or the possibility of the case ending up in court, or the end of the case. So what did I do? I was forced to agree to a $500 fine and pay court costs. It was cheaper than trying to find more money for the lawyer, yet the prosecution had lost the evidence, and this was in 2010 under the current arrangements. Has anyone looked at how much a person earning $22,000 a year actually is in real terms? After tax, a person earning $22,000 takes home $330 a week. The cheapest rent for 1 bedroom in Auckland is approximately $200 a week. That leaves $130 for food, transport, medical and possibly childcare. They could possibly have 1 dependent. What portion of New Zealand earners are in that area? These are people working in the fast food business, waitress staff and the like, students working part-time, shelf packers, the low-income earners. And then she went on to talk about her daughter falling into that bracket, but owning a car, again, being her only asset. That changes to the changes to the current bill, she says, will require 90% of the population to pay for their own defence, from the person packing shelves right up to the company directors and owners. The 10% of the population who can get legal aid are the $0 to $21,000 a year earners. These are people that are unemployed or on sickness benefits, maternity benefits or other benefits, or those that fall into this criteria who take home $315 a week after tax. Where is the fairness in saying only 10% of the people are entitled to assisted legal representation? She made the point that actually, that in the Crimes Act, she quotes the Crimes Act, the fact that an offender is ignorant of the law is not an excuse for any offence committed by him. The reality is that many people are ignorant of the law, she says. There are so many laws. The people trust Parliament with the making of the laws to protect them, no to disadvantage them so they can represent themselves in court or plead guilty due to ignorance of the law. That's the problem. She pleaded guilty due to ignorance of the law. She wasn't guilty of the offence. She would have got off if she'd been able to defend herself, but the system failed her. The system let her down. And that is what my major concern is, and that is exactly what the concern was when it was expressed in the regulatory impact statement. Be careful what you wish for. Be careful what you do. Withdrawing legal aid for low-income groups is likely to lead to additional costs elsewhere in the justice system. In particular, it may increase the number of self-represented litigants with flow-on costs due to delays, additional assistance required from court staff and the judiciary, and higher numbers of appeals of decisions. And the one they missed out, pleading guilty to a crime you didn't commit. And that is going to happen time and time and time again, because it is much cheaper to actually, plead guilty and end up with a conviction, $500 and court costs, despite the fact that the prosecution had lost the evidence. And that was I wanted to mention a real case, a real submission in front of our Select Committee, because I think it makes it real for this House, and I don't think that this bill is good enough.
Alfred Naru.
Thank you. I rise to take a call on the Legal Assistance Amendment Bill, especially in regards